In South Africa, we recognize two basic types of marriages: a marriage in community of property and a marriage out of community of property. A marriage in community of property is the default position. In other words, if you don't sign what we call an anti-nuptial contract, a pre-wedding contract, you will automatically be married in community of property. This means that we have two parties in the joint estate which have to administer this joint estate together with the consent of their spouse, in other words. This marriage in community of property means that both parties are liable for each other's debts because they only have one joint estate. So if one party buys property, it falls under the joint estate once that property comes into the estate and is then also owned by the spouse. So that is a marriage in community of property. Marriages in community of property are no longer very popular because it affords no protection to the spouse whatsoever. So these days, it has become the general rule that parties will enter into an anti-nuptial contract before they get married. This means that the parties will be married out of community of property. In other words, both of them will retain their separate estates as if they never got married. The one spouse will also not be liable for the other spouse's debts. Now, under a marriage out of community of property, we have two options. The one is the normal, standard marriage out of community of property, where both spouses have their separate estates as if the marriage didn't take place, and this carries on for the duration of the marriage. At dissolution, and all marriages dissolve by death or divorce, nothing really happens. The husband will retain his assets together with the growth of those assets, and the wife will do exactly the same. In 1988, the accrual system came about. This is something that is very popular amongst young couples because it is still a marriage out of community of property, and that's quite important to understand. It's not a marriage in community of property. It's a marriage out of community of property, but at dissolution of the marriage, something happens. Now, the accrual claim, in a nutshell, says that at dissolution of the marriage, and it's important to again note that all marriages dissolve, so it doesn't matter what the reason for dissolution is. It could be death of the one spouse or divorce. But at dissolution of this marriage, the accrual claim must be calculated. This means that we look at the growth in the husband's estate for the duration of the marriage, and we compare that to the growth of the wife's estate during the marriage. If there is a difference in growth in these two estates, that difference must be split. So it doesn't mean that they're going to end up with the same assets or with the same net value, because at commencement of this marriage out of community of property, where the accrual system is applicable, the parties are required to note their commencement values in the antenuptial contract. So if the husband started off with a net value in his estate of 100,000 and the wife starts with 0, and they are married for 5 years and then the marriage dissolves, we then calculate the value of the husband's estate, assuming that that net value is 500,000 rands at this point, and assuming that the wife's end value, the net value of her estate after 5 years, is now for whatever reason 1 million rands. The husband's estate grew by 400,000, the wife's estate grew by 1 million rands. There's a 600,000 rands difference in growth, which means that the wife would have to pay the husband 300,000 rands on dissolution of the marriage. That is how the accrual claim works. It cuts both ways. The reason it is popular is that the parties are still afforded the protection of a marriage out of community of property where they have separate estates, they don't require each other's consent, but they still have that feeling that they share a common interest, and that is what makes it so popular. It is important to note that when you are selling property and the property is only registered in the husband's name, for example, and he's married out of community of property with the accrual system, he does not need his wife's consent to sell that property, even though the accrual system is applicable. Some parties think that because they're married with the accrual system being applicable to the matrimonial property system, the wife would have to consent before the husband could sell property validly. It's not the case. We said right at the beginning that it is still a marriage out of community of property, and even though she might be sharing in the growth at dissolution of the marriage, she still doesn't have any assistance required, or the husband doesn't require her assistance at all. He has full contractual capacity as a result of the marriage being one out of community of property.